Welcome to Partnerships for Profit, the podcast where we bring you inside the world of joint ventures, strategic partnerships, and powerful collaborations. Each episode, you'll dive into conversations with top entrepreneurs, visionaries, and business leaders, unlocking the secrets to building profitable relationships that drive growth and success. Whether you're looking to expand your network, find new referral partners, or scale your business, you're in the right place. Let's get started.
Welcome to Partnerships for Profit, presented by LeDuc Entertainment. Today we are joined by Dr. Bradley Kramer, who is a licensed physician and trial attorney and the founder of the trial offices of Bradley I. Kramer, MD Esquire. Bradley, welcome to the show.
Hi, how are you today?
I'm doing great. Thanks for joining us.
My pleasure.
Can we start off? Can you tell me a little bit about yourself and a little bit about the trial offices of Bradley I. Kramer, MD Esquire?
Sure. So I've been in practice since 2004. I graduated Stanford Law School at that time. Prior to that, I attended the University of Illinois for medical school and UCLA for a year of residency. And then prior to that, I attended the University of Michigan, as you can see in the background, for my undergrad studies, majored in biology. And since I've been in practice, I've focused principally on medical malpractice cases with some personal injury cases as well, some business cases as well, but primarily medical malpractice cases, always representing the patient and not the hospital or the doctors, and trying to get justice where we can.
Now, you are one of just a handful of people that have both the licensed physician and licensed attorney titles. Now, what inspired you to pursue both pathways, and how do they intersect in what you do?
Sure. So that was never the plan to begin with. The original plan was to go into medicine and just be a practicing clinician. And all of that changed sort of in the later years of medical school, the third and mainly the fourth year of medical school, where the students wind up going into the hospitals to treat patients. And I just felt that wasn't really my calling. And at the time, law school wasn't necessarily what I felt my calling was either. So I went to law school having graduated undergrad 1 year early. I had a year to play with. So after medical school, I was still ahead of the game. So I decided to apply to law school, and then I got into Stanford and I decided to attend. It worked great. I really enjoyed it. I liked the logical processes that were involved with determining how the law would turn out on one side or the other. So I finished law school. When I got out of law school, I actually wasn't even certain that I was going to be doing what I'm doing now. I started working at a couple of corporate law firms, entertainment law firms, real estate. And then only in about 2009 did I determine for myself, after the real estate crash around that time period, that I would go into plaintiff's law, meaning representing injured parties, injured victims. And so from there, I kind of gradually just built the practice. And it turned out that a lot of people wanted to send me medical malpractice cases because those cases, or at least those claims, are abundant in California, and they tend to require a lot of specified knowledge, which I had. So that, whether or not I wanted to go into that field, that was ultimately how things turned out. And then, when it wound up being that all kinds of cases were coming into my office without me advertising or doing any marketing for those cases, I figured, well, I should probably just go with that since they're coming in anyway. And so since 2009, that's been probably 90% of my practice.
How would you, now when faced with a medical malpractice case, how would you maybe evaluate that case differently than an attorney that didn't have your medical background and expertise?
So the thing about medical malpractice cases is they turn on very sophisticated medical knowledge and terminology. Unlike a car accident case, for example, where you have drivers who can understand whether the light was red or the light was yellow, or things that lay people can understand without needing to consult treatises and textbooks. Medicine really requires a fundamental understanding of the medical terms of the body systems, of how they interrelate, at least from some sort of foundational standpoint. So when a case comes into my office, I think it would be very difficult without that sort of fund of knowledge, that basic fund of knowledge in medicine to evaluate the case. And so every case that comes into my office, I'm required really to access that education and that training to evaluate whether there's actually a claim there.
Right. Now, and I'm curious, I guess this is a two-part question, right? What are some of the common misconceptions that people have about medical malpractice cases? And what are some of the common mistakes that you see people making when it comes to medical malpractice cases?
So that's an easy question to answer. The misconceptions of medical malpractice cases are, number one, that the person has a case, and number two, that it's going to be easy. I take anywhere between 20 to 40 intakes a day where people call my office and they believe that they have a case. And after listening to the person's story and oftentimes reviewing their medical records, it turns out that no, in fact, there isn't a case there. What people also don't understand is that just because there is a bad outcome or someone gets injured as the result of some care that happened in a medical clinic or at a doctor's hands, that doesn't necessarily mean it's malpractice. The definition of malpractice is that it's care or conduct that is unreasonable under the circumstances, meaning that no doctor or hospital or nurse or specialist would have done the same or similar in connection with treating that patient. So that misconception permeates really just about every call that I get.
Right.
And so I have to dig a layer deeper. And then, well, I forgot, what was the second question that you asked?
Oh, I was just saying, what are some of the common mistakes? There's misconceptions. Right. What are the mistakes that people make?
So generally, individuals, before they come to my office or when they come to my office, haven't made any mistakes per se. The biggest mistakes that I see are when other lawyers who don't practice medical malpractice wind up taking cases that are not viable. And they wind up spending quite a lot of money on either an initial intake review or actually litigating the case. And then it turns out that they have a fight on their hands, and the defendants don't want to offer any money in connection with that case. And then they've spent quite a bit of money, quite a bit of time, only to realize that they shouldn't have taken that case in the first instance. So that would be the biggest mistake that I see. A good percentage of my cases wind up being cases that either were taken by attorneys that got themselves in too deep and need to then refer the case to me and I accept the case, or cases where attorneys find themselves in a similar position and I look at the case and I say, actually, you should have never taken this case in the first instance.
Right. When you're presenting a case to a jury, how do you sort of bridge the gap between legal strategy and medical knowledge? How do you sort of combine those things?
Juries generally tend not to have any understanding of medicine.
Right.
If they do, if a juror does have an understanding of medicine or an involvement with a nurse or a doctor or a hospital, generally they get stricken from the jury. They get taken off using one of our challenges. So the people that wind up remaining on juries generally don't have any knowledge of medicine. So you really have to explain it to them as if you were explaining it to a layperson. I've been in situations where I've seen other medical malpractice lawyers try cases, and some of the language that they use tends to be very much over the head of the jurors. So when I'm in trial, which sometimes you have to try these cases in order to keep the defendants honest and make them understand that there's liability, you really have to specifically think about how you're going to phrase injuries to a jury so that they can understand them. For example, now I don't want to go into too many examples, but if a lawyer were to say to a juror something relating to the carotid artery, most jurors are not going to understand what they mean. So you really have to state it in terms that a layperson can understand. It would be the tube or the blood vessel that goes through the neck and supplies oxygen through the blood to the brain. That's a way that you can sort of, I hate to say this because I'm not saying it disparagingly, but to dumb it down sort of, so that they can understand that. And so you really, when you're explaining these things to a jury, You have to do it in terms that they can understand, because otherwise the medicine just goes way, way above them, as it should. And as far as the legal strategy, you have to then incorporate those medical aspects with what you're trying to prove.
Right. Now, your practice is based in the Los Angeles area. Is that correct?
Correct. We're based in Los Angeles, but we take cases all across California.
And in California, you are under the Medical Injury Compensation Reform Act of 1975. Is that correct?
Correct. As amended in 2022, and then it took effect in January of 2023.
And can you explain a little bit about what that is and how it impacts victims' rights in California?
So there are a lot of states across the United States that limit the amount of pain and suffering that can be recovered by a victim of medical malpractice. Now, that contrasts starkly with the injuries that are compensable in routine or garden variety personal injury cases, such as slip and falls, car accidents. And that's one of the reasons why you see a lot more attorneys practicing in those areas than you do in medical malpractice cases. One is what's called the micro law, which you previously alluded to. And the second is the costs associated with litigating these cases. And also that they're defended so aggressively by doctors, because doctors don't generally take lightly to being sued and having to ask their insurance companies to pay out damages on their behalf. That being said, MICRA is an incredibly, in my opinion, unfair law that unconstitutionally limits the amount that a victim can recover. It basically takes the right of the jury away from a victim, because any jury award that comes down that is in excess of those awards will be post-trial reduced by a judge. Which I think is incredibly unfair. That being said, the original MICRA law called for a cap of $250,000 for pain and suffering. As of January 1st, 2023, that amount was increased to $350,000, with an increase of $40,000 every year for the next 10 years until it gets to $750,000. Another aspect of the reforms to MICRA is that the wrongful death damages used to be among the damages included with that $250,000 cap. That cap has, as of January 1st, 2023, been increased to $500,000, and that increases $50,000 per year for the next 10 years until it hits $1 million. And after those two limits get reached in 10 years, then there will be a yearly increase for cost of living to make those caps more fair, or I should say less unfair going forward.
When clients come to your firm, is your strategy sort of a one-size-fits-all approach, or is everything you do at your firm very sort of highly custom tailored to the individual and their individual case?
So in my firm, I do all my own individual intakes. The reason for that is because I feel that every case is very different, and every case needs to be evaluated by someone with medical training. So every case is evaluated independently, even in cases where the injury winds up being the same or similar, such as, let's just say, the cutting of a gallbladder bile duct, which, again, if I was explaining that to a jury, I would explain it in very different terms. But even in those cases, the surgical notes that reflect what the surgeon did in that circumstance are never going to be exactly the same. So each case really has to be evaluated differently. And I can tell you that just using surgical cases as an example, I've had many cases where the actual injury is the same, but the liability is very different based upon the person's medical history, whether they had prior surgeries, any economic damages that they may or may not have. So yeah, every case that comes into my office is very custom tailored to those specific facts. And for that reason, I'm not able to have a mill of cases rolling over and over where I can have 100 or 200 cases in my office at the same time. I take a very limited amount of cases because of the personal attention that each case requires, because they're all different.
And can you tell me a little bit? I'd love to dive in a little bit more about that. What does the sort of discovery phase look like when you're trying to find out the specifics of a case and what damages were done?
The one thing that is very different about medical malpractice cases, or I should say one of the things that is very different about medical malpractice cases and personal injury cases, is generally there's not a whole lot of discovery, at least written discovery, that needs to take place because everything is chronicled in the medical records. There are certain circumstances where depositions need to be taken to further elucidate or further show what the doctor or nurse or other treating provider was seeing or doing at a particular time with regard to the care of the patient. But for the most part, everything that the doctors or nurses do is in the medical records. So discovery is a very different entity or process than it is in a lot of other cases. And that's a fortunate thing, because discovery obviously takes time. It's expensive.
Right.
And so a lot of the information for these cases can be gleaned on first glance when the initial records are procured.
Now, you mentioned that you started in 2004.
Correct.
And I'm curious, over 20 years now, and I'm curious, I guess, are there any trends that you have seen come and go in the medical malpractice space and the legal space? Is there anything that you've seen change over those 20 years?
Well, the biggest change that I've noticed has been with the change of MICRA. And the studies bear out those changes, which is that the average recovery for a medical malpractice case has gone up since that time. You also see, or I have also seen, some level of attorneys who previously wouldn't touch medical malpractice cases now trying to get into that field because they are a bit more lucrative than they used to be. But the biggest change that I see going forward is going to be the incorporation of AI and the incorporation of robotic technologies, which is going to take a lot of the human error out of medical care and put it into the care of computers. Right. So not only is diagnosis and treatment and the plans for that going to be made by computers based upon peer-reviewed studies and historical data, but when someone goes into the operating room for brain surgery, for example, or heart surgery, a lot of that surgical care is in at some future date going to be taken over by robots who are going to be able to do it with much fewer complications.
Right. Did the COVID pandemic have any impact upon the medical malpractice space?
Not really. I mean, people are always going to need to see doctors. I think a lot of the cosmetic care cases, plastic surgery cases, were put on hold for a bit. Right. So there may have been a slight dip in those intakes that I was doing. But as far as necessary care was concerned, I think people were still going to the hospital for heart attacks and gallbladder surgeries and problems with their eyes. So it wasn't as big of a change as there were in a lot of other fields like car accidents, where literally no one was on the road for some period of time. And I think a lot of attorneys felt the impact of that at that time.
Right. How do you approach working with clients who are victims of life-altering trauma, do have permanent injuries as a result of medical malpractice? How do you handling with them? I mean, how do you approach that?
It's tough to handle these cases because there's so much emotion involved. Even in minimal injury medical malpractice cases, they tend to be very emotional for the plaintiffs, because not only is there the injury, but then there's the additional complication that they lose their faith in the medical system. And they lose their faith in doctors. So that can be very emotional. I've handled cases of those types of minimal injuries, and I've also handled cases of quadriplegics, people who have no longer have any use of their arms or their legs. In one of those cases, we were able to settle the case for $15 million, which was a life-changing amount for that individual. What I try and do of necessity is I really try and distance myself from the emotionality of these cases.
Right.
Because if I wind up getting emotionally involved, I wind up making decisions based upon the injury and not the liability. So as much as I do feel for my clients, and I walk through the process with these clients from start to finish, I do have to, by necessity, distance myself on some level from the emotions that these people feel. And after the case is resolved, I sometimes have had situations where I've sat down with clients and we've all just cried and bare our emotions about what's happened over the past, whether it's 6 months, a year, or 2 years or more. But these cases tend to, like I said earlier, tend to be defended aggressively. And if one lets emotions get in the way, that can complicate looking at the claims objectively and looking at the liability objectively. So, but I understand, and I never take for granted the gravity of my task, which is to potentially have a life-changing impact on the people that I help.
And you've recovered over 100 million for your clients. What do you attribute that overwhelming success to?
I think that the main issue, or the main reason why I've been able to be successful, is twofold. Number one is being selective on the cases that I choose, because I only have a limited amount of time to evaluate and litigate a certain number of cases. And the second is litigating these cases aggressively. As we discussed earlier, I have a good fund of knowledge for medicine that allows me to really delve into the medical records and to the treatment received by the patient, and to really be able to argue for those patients aggressively and to advocate for them. Sometimes I do need experts to help me with that, and sometimes I don't. But either way, whether I have an expert or not, I always have the ability to explain those facts to, whether it's a mediator or a jury or a judge or the defense counsel, why my position is what it is and why I think they should be paying X amount of dollars on that case. So I really do take a personal interest in every client that I serve, and I try and maximize the value of those cases. So I think that my honesty and my ability to fully disclose every aspect of the case to my clients and have the same level of expectation that they have from the very get-go has allowed me to be successful.
And you support numerous charities as well, is that correct?
Yeah. I've really been a big fan of the Diane Fossey Gorilla Fund ever since college. All of the animal rights charities I tend to have an interest in. I support some political charities as well, but I'll leave those off the table for now. But I am a big fan of animal rights and preventing against habitat destruction for endangered species. I think that's a huge issue that we now face as humanity, as a society. So I try and do everything I can to protect those animals.
That's incredible. And you are very well traveled. Can you tell us a little bit about that?
Yeah, sure. Yeah, I feel like I forgot who said it once, but they said that basically the earth is a book and you got to read the whole book. You got to try and read through all the chapters. So I like to get around. I like to see what the earth has to offer, knowing that I'll probably never be here again. Who knows what happens after, this lifetime is over. But the earth has some amazing sights, amazing countries, amazing cultures. So I like to travel the world and see what I can see. I've been to essentially every continent except Antarctica.
Wow.
And some of my favorite places have been places where I would not have expected to have had such a monumental impact on my perception of the world.
Is Antarctica on the bucket list?
Sort of. I mean, you got to go down to South America and then get all the way into the south of South America. And then I think you land in Ushuaia. I think that's what it's called. And then you take a ferry over to Antarctica. So it's quite a hike to get down there. But I've been to Greenland, which is similar. Whether or not I get down to Antarctica and when is yet to be determined.
Now, I'm curious, I mean, whether it's, through the firm with your clients, whether it's through your support of charities. Everything you're doing is just really focused and centered around helping people. Is that something that's just innate to your character? Is that something that you've managed to cultivate along the way? Where does that drive to help others come from?
I think that originally, when I first started my practice, my goal, or first started getting into medical malpractice, my goal was really to do something that I really enjoyed, um, and something that I really liked diving into. And medicine has always been a topic that I really enjoyed, at least the academic aspect of it,
Right.
and understanding how the body systems work. As a result of that, I've been able to generate and cultivate relationships not only with other attorneys, but with my clients. And I think when you see, or when you start to see, the impact that these cases can have on a client's life, and how grateful some of them are for what you've done for them,
Right.
you can't really help but be affected by that and want to continue that. So that really, it's a bit selfish of me, but the feeling that I get when I'm able to help somebody in that regard really warms my heart, and makes me, it gives me that endorphin release, which makes me want to do it more.
Right.
So, in one aspect, it's selfish. I'm doing something that I love. I'm able to have had a career and continue to build a career doing it, while at the same time really benefiting other people. So it's kind of a symbiotic relationship, and I still love what I do, and I can't imagine not ever being a lawyer, because I do on a day-to-day basis. Every job has its pitfalls and its bad aspects, but on a day-to-day basis, I really do enjoy what I do.
When you think back on all the people that you have helped through the firm, is there a case that really stands out? Is there an individual, a client, a story that really stands out in your mind of someone that you really saw a positive outcome or a positive transformation in as a result of your help and guidance?
Sure. I mean, to be totally honest with you, while I've had many multi-million dollar settlements over the years, the case that has stuck with me the most, to be honest, was a case that I litigated all the way to trial towards the beginning of my career. And we actually lost that case. It was a case where one of the jurors, even though they seemingly were in favor of our position, one of the jurors, after the case was submitted to them, sent a note to the judge saying, if we find the defendant liable, is this going to impact his medical license? Which is something that a jury is really not supposed to consider when rendering their verdict. They're only supposed to consider the facts of the case. So I knew that we had presented a good case, but I also knew that that juror or several jurors were considering that other aspect of the case in rendering their verdict. We ultimately lost that case. It was a wrongful death case, and I specifically remember the wife of the decedent and the child of the decedent, and we all had an incredibly emotional cry session at the end of that case, even though they had lost, and they were effusive in thanking me for all that I had done and giving them the opportunity to present that claim to the jury. And they knew that I had worked my butt off for the case and that we presented a good case. And they were so thankful for my efforts. And that case still sticks with me. So I know that even in a case, whether win or lose or settle, if I can have a client who's appreciative of my efforts, knowing that I've done everything that I can to get them a recovery, then again, that's a bittersweet moment, but it's not something that I look back on with bad feelings.
Right.
The settlements, of course, are helpful and they're great. And when you have send a settlement agreement to a client for millions of dollars, I mean, that always puts a smile on my face and their face. But those are sort of easy moments to be happy with or to remember. It's the harder moments that affect you long term, like the one I just explained, that are really most meaningful to me.
Right. What advice would you have for a young attorney looking to get into the medical malpractice space?
The first thing that any medical malpractice lawyer or aspiring medical malpractice lawyer needs to know is that they have to acquire somehow that baseline fund of knowledge of understanding how the body systems work and interact, and taking certain diseases like diabetes that really impact just about every bodily system and learning the interaction of the organs. It's very difficult to go through a medical chart without knowing what to look for, and knowing where the pressure points might be in a medical chart. That may require reading a book or taking a course or calling me. I'm always happy to talk to young attorneys and counsel them and explain to them why something may or may not be a case. But I think that getting into this field, which has certainly a lot of pitfalls of its own, including MICRA, including the upfront costs that are often required in these cases and the time that it takes to litigate and oppose these cases. I always tell attorneys, young attorneys, to take a pause before jumping in head first. But that being said, I mean, it's a very rewarding field for young attorneys to get into, if you had to take my experience as an example.
Well, Dr. Bradley, this has been an absolutely incredible conversation. If anybody out there listening could use your help, could use the help of the firm, where can the people find you?
Sure. I have a couple of websites. The easiest one to remember is calldrbrad.com, all spelled out. I also have 424injured.com. And my number is either 424-INJURED, or they can reach me at 310-289-2600.
Well, Dr. Bradley, this has been absolutely incredible. Thank you so much for coming on the show.
My pleasure. Glad to be here.
And thank you, everyone, for listening. This has been Partnerships for Profit, presented by LeDuc Entertainment. Dr. Bradley, thank you again.
Thanks very much.
Thanks for joining us on this episode of Partnerships for Profit. We hope you've gained valuable insights on how to form profitable partnerships and take your business to the next level. Be sure to subscribe and leave us a review wherever you listen to podcasts so you never miss an episode. Got a partnership story to share or someone you'd like to see featured on the show? Reach out to us. Until next time, keep building those partnerships for profit.